This person was asking, what was the most shocking tactic that the WMS has tried in your trials?
Is that a question for me?
Yes, I suppose so. You or Michelle.
Well, shocking.
I could think of one.
I guess,
shocking.
Say it again?
I said I could think of one that I remember being sort of shocking, I guess. I don't know if that's the right word, but and this would be back when they sued me in the beginning, when the judge asked them for the statements that they quoted in the complaint, and they couldn't produce them or wouldn't produce them. And the judge would say, well, but you quoted directly from somewhere to draft the complaint, like the statements are in quotes, where are those statements from? And they kind of danced around it and just wouldn't give the statements, and it was just really weird for me sitting there listening to this, because I'm like, you drafted the complaint from something, but they're sort of pretending that they didn't know where it came from, or that it was members who had brought the information to them, or just something very vague. When they were suing for $12 million, to me was a bit shocking. That
take our word for it.
Yeah, like you should, and they would say that. So the pleadings have to be taken on their face and all this other stuff, and you would think that in a lawsuit against someone for $12 million that you would at least have a copy of the statement that you're alleging is defamatory, like ready to go if someone would ask. And they it was almost 2 years, I think, before we got statements from them, and we didn't get all of them. And then that kind of spilled over into the cases that we have now, because I don't know if it was inadvertently or what, but they later submitted statements that they should have given to us years ago, and they didn't. And I think that they didn't realize that the statements or the documents they gave they were proof that they had the statements in their possession when the judge continuously asked and ordered for them to produce them. And so they were ultimately sanctioned for that conduct. That was one of the motions that Peter and I put together. I think it was like 2 years ago or something. So that to me was shocking, because, why hang on to those statements? Why keep saying that you don't know and you have to get subpoenas from Yahoo and every other place that you say the statements were when you had them in your possession to begin with? So that was one of the things, but Peter might have something else.
Well, look, I don't shock easily, particularly when it comes to the question of the tactics that opposing lawyers can pull. I've seen a lot of stuff. The 11 years fighting Nexium gave me plenty of instances of sort of incredible nonsense. But it doesn't fit in the category of shocking. But I think what is probably the most important tactic that the church tried in the history of these litigations was their use of something called the church autonomy doctrine. The church autonomy doctrine is basically one that says that civil courts should not be in the business of ruling on whether or not a church's practices and beliefs are valid, are good or bad. Civil courts shouldn't be making judgments about church belief. And for quite a while in these litigations, the WMS had used that doctrine, I would say hidden behind that doctrine, to deny access to virtually every document that they had, which would have proven the validity of Michele's case and of Raymond's case, saying, "Well, no, these are internal church documents about the way we believe and what we think," and fortunately for them, they had one intermediate level decision out of New Jersey courts that ambiguously seemed to support their view that they could protect some of this stuff. And ultimately, I was able to restructure what it was that decision was saying, and bring a new motion back to the trial court to basically say, look, the church autonomy doctrine should not be used or should not be allowed to block access to these materials, because I'm not asking you, Your Honor, to rule on whether or not what the church does or says is good or bad or right or wrong. All I'm asking you to do is to look at these documents and say, it exists. No judgment, no, whether or not I agree with what the doctrine says or I disagree with it. All I'm asking you, Your Honor, to do is to recognize that this doctrine on this piece of paper exists in the church. And the court accepted that. It went up on appeal. And on appeal, this time around, the appellate division said, yeah, that's right. That's the way to look at the church autonomy doctrine. It is only when the courts have to decide good, bad, right, wrong, not exist, don't exist. So that, as I say, that the use of the church autonomy doctrine to try to keep everything under their control that would prove our case was about as problematic a litigation maneuver as I had to fight my way through, but fortunately we were able to do that.